And we're rolling. Hello and welcome to another edition of Car Brief, a website devoted to all things automotive related as it pertains to litigation. And hopefully I will be brief, as the title suggests. Just wanted to run a little thing by you people with regards to a case I had today up in court. It was a motion to dismiss on a case that involved a patient confidentiality. I'm not going to get into the details of it, obviously, but during the motion to dismiss, there was a little thing that came up. Initially, the case was about a third party that was present during the reading of some medical information. And this party was a friend of my client that I had indicated dropped off my client to the hospital. Well, I used that a number of times during the argumentation of it, and the judge finally looked at me and said, well, you indicate this individual dropped off your client. Do you want to explain to me, counsel, how it is that this individual ended up in the hospital in the first place? And I'm thinking, wow, that came out of left field like a real zinger. Just, wow, where'd that come from? So I'm thinking, well, and I quickly recovered, incidentally. I said, what happened was this individual dropped off my client at the front door, went and parked his vehicle, and then came into the hospital. So the judge looked at me for a good 2 or 3 seconds, maybe 4 seconds, and said nothing. And he just seemed stunned by that recovery. And he looked up to the ceiling, tilted his head, and then kind of shrugged his shoulders and just went on discussing other issues in the case. So it was a rather quick recovery on my part. I kind of surprised myself, actually, because in the heat of argumentation, it doesn't always work out that way. So this one happened to work out fine, and I recovered from the stall of the airplane, so to speak. Okay, so we're going to move along here. This case that I'm going to discuss tonight is a case involving some exotic Italian automobiles, Ferraris namely, and a Bugatti, and a transaction that went horribly wrong. This is the case of Schuster versus Dragon Classic Motor Cars. It's a federal court case that came out of Connecticut, I believe. It's 104 Federal Supplement 2D 276. It's a 2000 case. And let's begin. Let's get into it here. Okay, this case involves a plaintiff, Mr. Schuster, who is a collector of antique automobiles. And he contends that the dealer, the defendant dealer, Dragon Classic Motor Cars, and his two principals, defendants Emmanuel Dragon and George Dragon, defrauded him in two separate transactions. The first, an alleged loan of $2,125,000, and the second, the purchase of a 1939 Bugatti Type 57. He's got good taste in automobiles, I'll give him that. His claims include breach of contract based on the defendant's failure to repay the note, fraud, breach of fiduciary duty, unjust enrichment, and violation of the Connecticut Unfair Trade Practices Act. So he threw everything at him that he could in this lawsuit. Well, the defendants had something to say, and they counterclaimed based on the plaintiff's alleged failure to pay for repair and restoration services performed by the defendants and for the plaintiff's automobiles. So, as you can tell, the plaintiff and the defendants, they've had a past, prior to this incident, this litigation, they've had a past with dealings with each other. Looks like there's been some restoration work that was going on prior to all this. So during the course of the trial, and this case did go to trial, the parties settled all their disputes relating to the 1939 Bugatti Type 57 and the defendant's non-payment of claims, leaving only the dispute concerning the alleged $2,125,000 loan for resolution. So let's take a look at the facts here before we get into the court's reasoning as to what they're going to decide. The general background of this case involves a situation where Dragon was seeking to acquire a number of antique automobiles from an Italian bankruptcy court. The financing was to come principally from a foreign investor, one Cogan, who allegedly was to have been a partner in Dragon's acquisition of the vehicles. So far, so good. At a critical juncture, however, Cogan was unable or reluctant to come up with the money as promptly as was required. So Dragon approached Schuster for a $2,125,000 bridge loan. Schuster agreed to lend him the money on the condition that he receive a short wheelbase Ferrari California Spider automobile, one of the vehicles to be acquired in Italy, at a very advantageous price in a partial repayment of the loan, with the balance to be repaid in cash. I like his taste in automobiles. So far, so good. He wired the money to Dragon's attorney on June 4th, and the attorney promptly wired it on Dragon's Italian contact. On June 7th, Dragon and his brother George Dragon and Dragon Classic executed and delivered to Schuster a promissory note in the principal amount of $2,125,000. Under the terms of the note, the obligors were obligated to pay Schuster $1,675,000 in cash on June 21st. The balance of $450,000 was due on September 3rd, but the defendants agreed they would transfer title and deliver the California Spider to Schuster by that date, in which case Schuster would waive his right to payment of the balance. So much is essentially undisputed, but the parties here part ways. So, in mid-June, Dragon learned that Cogan needed more time to come up with the money and claims that he contacted Schuster with a view to Schuster replacing Cogan in the deal. Schuster, according to Dragon, agreed, although Dragon was very vague and inconsistent about the alleged terms of that agreement. So on direct examination, Dragon asserted that Schuster agreed to stay in the deal if he could get more and better cars, thus implying that Schuster agreed to become a partner in rather than a lender to the venture. So they're looking like they're modifying the deal here. It's no longer you're going to be the loan, the lender. You're going to now become a partner, and you're going to replace this guy, this Cogan. So as it turns out, Schuster, according to Dragon, wanted a total of 3 cars: the short wheelbase California Spider, a short wheelbase Berlinetta steel body, and the 500 Testarossa. Schuster allegedly said he did not want his money back, he wanted the cars. Well, I can understand that. But Dragon told a somewhat different story on cross-examination. Question: Mr. Dragon, you say you had an agreement with Mr. Schuster that supersedes the original loan. Is that correct? Answer: correct. Question: the agreement to that you had with that Mr. Schuster was supposed to receive a Ferrari Testarossa and the Ferrari California Spider, and the Berlinetta, correct? Answer: correct. Question: he was to receive nothing else, correct? Answer: well, you see, the agreement was open-ended, and this had been the problem right along here. I agreed to give him a $200,000 discount on each one of these additional cars, and if there was anything else there that he wanted, he was either going to supplement, put more money in, or receive just these cars and maybe get some money back. It was open-ended. None of us went into this deal having seen any of these cars. The cars were not looked at. We didn't know the exact values. We didn't know the exact condition. So they're essentially buying cars from Italy where they haven't seen the cars. They're sight unseen. It's questionable whether these cars even existed, I would contend. But in any event, Schuster didn't agree to any of these versions. He denied that he had reached any agreement with Dragon beyond the promissory note signed on June 4th. So Schuster's saying, I'm just a lender. I'm not agreeing that I somehow substituted myself in as a partner to this venture. So the court went on to say determination of where the truth lies here is rendered more difficult by the substantial problems with the credibility of both Schuster and Dragon. So essentially the court didn't believe either the plaintiff or the defendant, didn't think either was credible. The two had done business in antique automobiles before, and the record clearly shows that they collaborated in preparing documents that falsely and in at least one case dramatically understated the prices of automobiles purchased by Schuster from Dragon, which Schuster then filed with the Department of Motor Vehicles for the admitted purpose of defrauding state sales tax collection authorities. So there's a little bit of monkey business going on here on all the parties, where all the parties are concerned. So everybody's trying to get the best deal they possibly can, and the state sales tax collection authorities look like they're going to get basically screwed on this deal. All right, so moving along here, the court indicated that when Dragon learned that Cogan was reluctant or unable or unwilling to come up with the necessary funds on schedule, Dragon did approach Schuster about staying in the deal rather than being repaid in strict conformity of the note. Schuster agreed to defer payment on the note pending further developments in the transaction. Certainly discussed for Dragon the possibility that he would be repaid in automobiles rather than cash once the cars were received. It looks like he'd be repaid in automobiles that were undervalued, as the court indicated. Well, moving along here, as things developed, the cars never arrived. Are you surprised? I'm not. It appears that the funds that Dragon put into the deal in Italy, including the money borrowed from Schuster, were stolen. What a shocker. Dragone has made substantial efforts to recover the money, but has been almost entirely unsuccessful to date. Not surprised. Stated in colloquial terms, the question is whether the loss falls entirely on Dragone because Schuster was simply a lender to him, or whether instead Schuster must bear part of the loss as Dragone's partner. So that's the whole issue on appeal here. And the court went on to discuss the core issue in the case is whether Schuster and the defendants entered into what's called a novation, which supersedes the June 4th promissory note. And the court said no, there was novation, a no novation, because a novation requires, one, a previously valid obligation, that's the obligation to pay the note, two, agreement of all parties to a new contract, three, extinguishment of the old contract, and four, a legally valid new contract. The court said, after hearing all the evidence, they find that the requirements are not all satisfied for a novation. So what the court's saying that the only agreement was that Schuster would not insist on immediate repayment and would discuss taking automobiles in repayment in the event the automobiles were obtained. There was no agreement to extinguish the note. So the court is saying, well, this note is still valid. There was no novation. Schuster's not, didn't agree or assent to becoming a partner to this venture. He's just a lender. So for the foregoing reasons, the plaintiff shall recover from the defendants jointly and severally the sum of $2,125,000 together with interest. And of it will be $1,675,000 at the prime rate plus 1% and $450,000 at the statutory rate of 9% in each case from the date of commencement of the action to the date of judgment. So what's the takeaway from this whole case? I would submit that the takeaway is be careful when you're going to buy a car, especially if you're spending a lot of money on it. If it's out of state, you're going to want to actually take a trip out there and look at the vehicle with the funds with you. Inspect the vehicle, see if it's something you genuinely want, and make sure there's a wrench of delivery. There's a delivery of the keys and the title in your hand in exchange for the money, as opposed to trying some overseas transaction thinking you're going to get a great deal, because if it's sounds too good to be true, it probably is. And I can't counsel you enough to actually go and see the vehicle. Me, I flew out to Connecticut back in 2000 to buy a Saleen Mustang. I actually flew out there to look at the vehicle. I had the funds with me, and the deal was sealed. I was able to look at the vehicle, hear it start. I knew that the vehicle existed. You're going to want to make sure that the vehicle actually exists so you're not being conned by some scam artist. So do your due diligence. And I'm going to sign off here with the closing remarks that this is for entertainment purposes only. And if you require the assistance of a lawyer, I would counsel you to seek out a lawyer for any legal issues you have as it pertains to anything automotive related and as it pertains to the state in which you live, because state laws vary from state to state, and you're going to want to be able to consult a lawyer in order to get the correct advice. And this wraps up another episode of Car Brief, and I plan to upload videos on Tuesdays and Saturdays, and I will get those out there as best I can. And enjoy the evening and happy motoring. Drive safely, everybody. Good night.